The Arizona Court of Appeals in the Braybaugh v. Dean case addressed whether stock options granted to an employee's spouse during the marriage are community property. The parties agreed the stock options that vested during the marriage were community property. However, they disagreed whether stock options given to Braybaugh during the marriage that had not yet been vested when the divorce was filed were community property or the separate property of Braybaugh. The Arizona Court of Appeals noted there was no case law on this issue in Arizona, so it looked for similar case law in California and applied two separate formulas to address this issue, namely the Hugg formula and the Nelson formula. The appellate court concluded that the characterization of unvested stock options as community or separate property depended entirely upon the reason the employer granted the stock options to the employee. If the stock was granted in recognition for past performance, the Hugg formula would apply. If they were granted for the purposes of retaining an employee into the future, the Nelson formula would apply to discern the community versus separate property interest in the unvested stock options.